defame the plaintiffs. Number two, alleged in a conspiracy to defame the plaintiffs. Number two, what we think is crucial about Cardno's finding is that the court commented that the petitioners in that case were involved
we have my microphone
in
on.
an effort to directly
Oh my
petition.
gosh.
Yes, the conduct at issue involved 4 paragraphs in a magazine article, but they had previously directly engaged with federal agencies responsible for environmental protection and the like. What Mr. Carney is now trying to do is convert whatever history he may have had, in his words, of exposing corruption or going after the police, and making that what he was doing here, when what he is alleged to have done here is not criticize the DA's office or criticize the police department, but very directly accuse private citizens of murder. So that is, I think, never having petitioned the government directly as the activists did in Cardno. So we see Cardno as standing for the important proposition here that anti-SLAPP protected activity has to be tethered in some way to an effort to directly seek redress from the government or indirectly seek redress from the government. Here, Mr. Carney has not argued in any way that his false accusations against our clients that they had committed murder was a message that he conveyed to the government, that he intended to be conveyed to the government, that he had any mechanism for reporting to the government. And on the one occasion where he actually was given an opportunity to directly petition the government on the issues, he declined by invoking his rights under the Fifth Amendment because he believed, rightly so, that responding to inquiries in connection with any sort of petition would expose himself to criminal culpability. So that's why we think Cardno is important here.
So is the relevance of his invocation of the Fifth that he did not avail himself of the opportunity?
Correct. I think one of the things that the court is going to be asked to consider is whether there are objective indicia, and this is from Blakesley, objective indicia of the plaintiff's intent to reach a governmental body in his petitioning activity. And one fact that I think is important here is that of all the activity he engaged in, all of which was, in our view, non-petitioning and not intended to reach the government, or designed to reach the government, when he had an opportunity to petition the government, he declined to do so. We think that's an important objective indication that his intent was not to reach the government. In fact, his intent was to attack and defame private citizens.
So, what do you say to the relevance of the Fifth Amendment?
There is no relevance to the invocation of the Fifth Amendment because he's being sued for his statements that he made well outside of the courtroom. Those statements were petitioning. The suggestion that Mr. Carney did not intend for his message about Karen Read's innocence and the plaintiff's guilt to reach the government is belied once again by the allegations of the amended complaint. They admit that Mr. Carney was responsible for the hundreds of people who showed up at the Dedham courthouse every day during that trial to protest. Who were they protesting? They were protesting the prosecution of Karen Read. Who was prosecuting Karen Read? The government. Mr. Carney is clearly the leader of the national Free Karen Read movement. And what do the words Free Karen Read mean? What do they signify other than a demand, a petition that the government do something or stop doing something? That's what he did. Obviously, his words we reached the government. You have in the record, early on, in some of his Canton cover-up stories, a directive to his readers: email Michael Morrissey at mmorrissey@state.ma.us. That's in one of the very first Canton cover-up articles. He says repeatedly that our presence protesting and doing standouts is intended to let the government know that we are watching and that we will not let an innocent person be railroaded. The anti-SLAPP statute doesn't extend just to speaking in court or petitioning the government directly, as in filing a police report. It extends, and I know Your Honor knows this, to statements that are reasonably likely to enlist public participation in an ongoing judicial case. I would submit that Aidan Carney successfully enlisted the greatest degree of public participation in a judicial proceeding in the history of this Commonwealth.
So let's talk about whether Mr. Carney was doing it on his own behalf or for his reading.
Yes.
It suggests that the claims against him, can't show the claims against him are based solely on petitioning activity. And they point to Judge Krupp's finding of an intent to influence and pressure the witnesses, as well as to Judge Doolin's finding that Mr. Carney's purpose was to interfere, obstruct, and there's a few other words. So what do you say to that?
Those rulings are not helpful on this motion in the court's text because they turn, as you just mentioned, on the question of intent. And the anti-SLAPP law provides that the motive behind protected petitioning activity is not to be considered at the first stage of the analysis, which is where we are. That's been the law ever since the Office One versus Lopez case, if not before, back in 2001. And the witness intimidation charges relate to conduct that is only partly part of this case. The witness intimidation rulings by those two judges do not analyze whether Aidan Carney's statements meet the statutory definition of petitioning under the anti-SLAPP statute. Instead, all those decisions say is that there's probable cause to believe that he may have, on the right proof, committed certain crimes that turn on subjective intent, and that is not helpful in the current motion. The current motion looks at statements. The question is whether the statements for which he has been sued meet the statutory definition of petitioning under the anti-SLAPP statute, and the question of motive is not to be considered. And that, not to get off the topic of Your Honor's question, but the commercial motive.
We'll get to that.
Okay.
So Attorney Manning, tell me why Judge Doolin and Judge Krupp's statements are relevant.
So, Your Honor, Judge Doolin and Judge Krupp's findings that Mr. Carney's activity was outside the protection of the First Amendment because it was activity that was intended to intimidate witnesses and harass witnesses is important because it provides you with some insight as to how other judicial officers considered whether or not that type of conduct was constitutionally protected and therefore likely to be petitioned. In fact, what Mr. Carney has done and what Ms. Reed has done by conspiring with him is pursued an unlawful campaign of harassment and intimidation, and a tool that they used in connection with that campaign was defamation. And so this, I think, the findings of Judge Krupp and Judge Doolin really just point to a truism. And that truism is, in the history of the United States, there has never been a case that we can find in which the court ruled that one citizen may publicly accuse another of murder outside of any reporting to government and be immune from civil liability for it. There is no case, Mr. Pyle has not cited any case. It would be a radical expansion of anti-SLAPP protections for this court to find that. And that is highlighted by Judge Doolin's and Judge Krupp's conclusions that what Mr. Carney was doing with respect to these witnesses, and again, I think it's important to separate what we've alleged in the complaint, which has to do with conduct directed towards these witnesses, versus other conduct he may have been involved in, relating to the DA or the investigation or whatever it may have been. What we've alleged is a course of conduct directed at these witnesses. What Judge Krupp and Judge Doolin analyzed was the conduct he directed at these witnesses, and they found that there was no constitutional protection for it, which is exactly what we are saying in this case, that there was no constitutional protection for his defamatory and harassing conduct. The defamation here being in service of an effort not to petition the government, but an effort to intimidate and browbeat these witnesses into changing their testimony. And we make a specific allegation in the complaint in that regard, where Mr. Carney says, this will all stop if you flip. He's not petitioning the government to get these witnesses to flip. He's petitioning the witnesses themselves, and he's encouraging others to intimidate them in order to create that outcome for Ms. Reed.
So, Attorney Pyle, along that issue, it would appear that your position is that the anti-SLAPP statute and the cases interpreting it precludes someone who has been publicly accused of murder by Mr. Carney from prosecuting an action such as this.
I'm sorry, Your Honor, I don't understand the question. Preclude,
Well, put another way, how can publicly accusing someone of murder be petitioning activity?
oh, easily. It depends on the context in which the statement is made. And I will have to say regretfully that the plaintiffs have broadly overstated the law about this. They say on page 20 of their brief that the law is clear that accusation of criminal conduct is only petitioning if made to the police or other law enforcement agency. That's on page 20 of their brief. There has literally never been a Massachusetts case that has said that. They cite 4 cases in support of that assertion, but none of them say that. And, of course, reports to the police are petitioning, but that doesn't mean that reports that, a statement that the police are investigating the wrong person, who the police should be investigating, are these plaintiffs, Brian Albert, Brian Higgins, Jennifer McCabe, Colin Albert. They should be investigating them. And the fact that they didn't even consider investigating them shows that this police department is corrupt. That's been Aidan Carney's thesis throughout this entire time. In a footnote in their brief, I note that the plaintiffs concede that generally raising awareness about police corruption is and can be protected petitioning activity, they say, but they draw this distinction. Accusing people of murder can't be petitioning. In this case, they are all part of the same ball of wax, because the reason that Aidan Carney believed that Trooper Proctor and the other investigators were corrupt was because they didn't even consider investigating the people at 34 Fairview on that night in question. Instead, they decided to protect, he said, a Boston police officer and other powerful people in Canton. The corruption is bound up inextricably with the allegation that plaintiffs were responsible for this murder and not Karen Reed. The North American Exposition Company case says that in deciding whether statements are petitioning, you must look at them in a context in which they were made. The context is extremely important. And to say in the abstract that it can never be petitioning to accuse somebody of murder ignores that line of cases. You must look at the context in which this all occurred. The pending judicial proceeding against Karen Reed, Mr. Carney's campaign to try to ensure that those charges would be dropped and that the plaintiffs would be charged instead. That is the context in which these statements were made. That is a context that contributes substantially to the finding that this was all petitioning.
Well, let's talk about context for a second, because many of Mr. Carney's actions could be interpreted as seeking to make the plaintiff's lives miserable. In fact, he says something where he said somewhere here where I read that they'll never live a normal life. The plaintiff cited Judge Salinger's decision in Clay Court versus Colton for the proposition that targeting private plaintiffs for punishment is not petitioning activity. What's your response to that?
The motive behind petitioning activity, once you establish that it constitutes petitioning activity, is irrelevant. And I would suggest, Your Honor, that it's helpful to look at these allegations on a count-by-count basis. That is what Crystal Asphalt instructs must be done. The defamation count.
You all did that in your submission.
Well, I would respectfully say we did it better than they did. But on the defamation count, Your Honor mentioned earlier that reviewing the complaint is the first step in deciding what a claim is based on. That entire claim is set up at paragraph 156 in repeatedly publishing false statements asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in the murder. Carney published numerous defamatory statements. That is the And then they list the harm and the fault and all sorts of other things that they say provide the foundation of the defamation claim. Absent from that is any allegation that he set out to make their lives miserable. Absent from that is any motive allegation, which isn't relevant in the anti-SLAPP context anyway. The statements that plaintiffs were responsible for the murder were part and parcel of his petitioning about the corruption of the case and everything else. That is what the defamation count is based on. And, clearly, we say all the counts are based solely on petitioning. But plainly, they state right there in paragraph 156 that that's the foundation of the defamation complaint. So anything else about notions of motives to make their lives miserable or that kind of conduct isn't relevant to that defamation, which is the central count in this case.
Want to respond?
I do. I have several responses, if that's all right, Your Honor, in response to what Attorney Pyle was saying earlier. You asked him earlier, why would accusing a private citizen of murder be petitioning activity? And he said, oh, easily. And then he didn't cite a single case in which that has ever been found. That accusations against another citizen, not funneled to the government, not a police report, not a tip to the FBI, not using an intermediary to inform law enforcement that somebody has committed a crime, just speaking it, that another citizen has committed murder falsely, as you have to presume in construing our complaint. He says easily that's petitioning activity, and yet nowhere in the history of the Republic, as far as we can tell, has any court ever concluded that. In fact, to the contrary, we cite cases where, as Attorney Pyle says, petitioning activity is found where citizens report criminal conduct to law enforcement. But in those same cut cases, and I would urge you to consider Bowman, which is a First Circuit Court of Appeals case, those same cases acknowledge that the reporting of criminal activity to law enforcement is petitioning activity, but then reporting of it to third parties is not. And in that case, the plaintiff was somebody who had been accused of sexual assault. The accuser had previously made a complaint to the FBI and another governmental agency. Subsequently, she informed people with whom that individual was doing business of the same complaints. And the First Circuit concluded that while the earlier reports to law enforcement may have been petitioning activity, the reports to third parties were not. And here's the kicker. The reports to the third parties were to staff of congressmen. And even there, the First Circuit held that that was not petitioning. And there are other cases that we cite in which wrongdoing is reported outside of governmental channels and not given petitioning protection. I want to talk about Attorney Pyle's comment about context, that it's important to consider context. They cite North American expositions for that principle. We cite it as well. The context that the court was considering in North American expositions wasn't the political climate. It wasn't the overall course of conduct. It wasn't, some atmospheric assessment of what was going on in the world. It was the context of the forum in which the statement was made. And there, the forum in which the statement was made was to the South Boston Community Foundation, which was created by the legislature, placed in the executive branch, and responsible for distributing public funds. And that was the context that North American expositions, which they cite, concluded was an appropriate forum in which petitioning activity occurs. Here, what they are encouraging you to do is say, Judge, consider the gestalt of what Mr. Carney was involved in. Consider that he was in, as a general matter, using his YouTube page and his for-profit entity to talk about issues. That's the context in which you should find that his accusations against private citizens of murder were petitioning. No, that's not what the cases say. The cases say, the North American expositions in particular says, that when considering context, it is the forum in which the statements are being made. And I think that that's a crucial distinction. I do want to say one other thing in response to Attorney Pyle.
Just one.
I can wait as well, because I know you came out asking questions, and I don't know whether just at some point you want to, whether we should make more expansive remarks, but I'm happy also if you have something that you'd like to key in on to the
Go
floor.
ahead, say what you want to say.
I wasn't quite, now I lost my train of thought. Oh, I think it had to do with intent and motive. It is absolutely true that the court should not consider Mr. Carney's motive at this point. And yet, Mr. Carney in his memorandum spends pages and pages and pages telling you that he was motivated by a sense of justice, that he was motivated to shed a spotlight on this criminal justice proceeding, that his motive was to spur others to action. None of that matters. Even if true, it doesn't matter. What matters is what he did and whether there is objective indicia of his intent. So his self-professed motives here, and the same with Mrs. Reed, don't matter. What matters is whether the record, with respect to the statements he made to our clients, presents objective indicia as to whether what he was doing was intended to reach the government. And here, what we say is that the objective indicia, the fact that he never actually reached out to the government, the fact that he declined an opportunity to do so, the fact that he encouraged his audience to use coded language to defame the plaintiffs. Coded language, meaning language that by its very nature would obscure the government from knowing what he was doing. The fact that he engaged in private confrontations suggests that there is an objective indicia that he was not looking to reach the government. That's what matters, not his after the fact self-comparison to Oliver Wendell Holmes. What matters is the objective indicia in the record as to what he did.
So don't worry, we'll get to it sometime. So, Attorney Pyle, let's talk for a moment about public participation. When I read your filings, I just get the sense that there's a little bit of overreach. And it's supposed to go to any statement reasonably likely to encourage consideration or review of an issue, and the language goes on. But how is posting to social media or encouraging people to participate in a Roman rally at plaintiffs' homes the type of public participation contemplated by the statute?
There have been a number of anti-SLAPP cases that have turned on use of social media to inform and mobilize other people. I had the very first one. It involved the plan to build a racetrack in the Plain Ridge Casino, and the Superior Court there held for the first time that posting on Facebook is protected by the anti-SLAPP statute. Posting on social media is the way today in which people connect with each other. Aidan Carney has done that to great success in getting people involved in these issues. Indeed, posting on social media and posting on the internet generally, I would point out, is what led your affiants Rita Lombardi and Paul Cristofaro to do things that are clearly public petitioning, going to Canton Town Meeting, going to the State House. Mr. Carney, by the way, this suggestion has been made, Mr. Carney never petitioned the government on his own, but they allege in their amended complaint that he was there protesting at the Dedham Courthouse. He was also up at the State House protesting to get the Attorney General involved in all of this. He decided that his words, his direct police report from Aidan Carney to the Canton police wouldn't have done anything. He wasn't a witness to this murder. He reasonably determined, the facts would show, that mobilizing thousands of people to protest against this unjust prosecution would be a way, potentially, to get the charges dismissed as he believed they should have been, by putting pressure on elected officials to do so. That is core protection.
Encouraging people to participate in a rolling rally.
The rolling rally, Your Honor, is very much participation and likely to lead to further public participation. That was a caravan of cars that started in a supermarket parking lot, went to various people's houses, didn't stay for too long, ended up with a protest in front of the Canton Police Department. that is I recognize that he's been indicted for that conduct, but nobody was, it was a peaceful protest in cars. And Mr. Carney is vigorously fighting, of course, the criminal prosecution for witness intimidation that arises out of that rolling rally. It was also heavily promoted online, such that people who weren't there could see, look, there's lots of other people who believe so strongly in this cause. They're going to go out on a sunny day and participate in a public event. That is also reasonably likely to enlist further public participation by others in this cause. So it is part and parcel of the petitioning activity in the case, and it meets the statutory definitions. Also, he's been sued, once again, for statements accusing plaintiffs of murder, statements that were made in connection with the ongoing criminal case. There's not just one element of the anti-SLAPP definition we're relying on. We're also relying on the statements that, at least during the entire time of the Karen Reed prosecution, his statements were made in connection with the pending judicial proceeding and were intended to reach the government directly or indirectly.
Let me turn to a few questions relative to the Reed motions. First of all, whenever you start arguing, I don't need to have the party spend any time on the 12b6 part. I can review the four corners of the complaint, or the other complaint, I guess whatever complaint I determine is the operative complaint, and I'll consider your written submissions. But let me start with the plaintiffs. Would you not have responded to the issue raised in the June 23rd amended motion to dismiss, or requested from the court more time to do so?
Your Honor, we do respond to the June 23rd motion to dismiss. It's our position that the opposition that we filed following service of both the June 18th and the June 23rd motions to dismiss address all of the issues raised in both of them. We didn't feel that we needed more time to respond. In fact, we thought that the appropriate course.
But you take the position that I shouldn't consider amended motion, the second motion.
Well, we do. I mean, we think it was a violation of the rules for them to serve it out of time without permission from the court. We think that it didn't comply with 9C. We think there are a whole host of reasons why the court shouldn't consider it. But if the court were to consider it, our opposition, which was served after we received service of both that and the June 18th motion, apply to both.
You took the time to have an affidavit submitted, which included a copy of the June 18th motion to dismiss.
Yes, we did do that. I mean, I'm not sure I understand
Well, then,
the suggestion.
why did you do that if you responded to the June 23rd?
Well, Your Honor, we thought it was important to bring to the court's attention what we consider to be Ms. Reed's gamesmanship with the rules of procedure. So she serves on us a motion.
That's why you did it. All right.
Yeah, that's why we did it.
So, Attorney Sullivan, apparently the original motion to dismiss that was served addressed the plaintiff's original complaint, not the first amended complaint. Is that correct?
The original motion addresses the complaint, which is extended
No.
by an amendment.
Hang on. It would appear, from what I saw, that, and I'm happy to give you, because I did compare and contrast of your original motion
Yes, Your Honor.
and the second, but what it appeared is that maybe someone responded to the wrong complaint. I don't know. But after the issue was brought to the attention, your attention, or whoever in your office, you unilaterally file an amended motion on June 23rd. Attorney Mattei references 9A. I might have missed it in 9A, but I don't quite see how you get to do that.
Well, Your Honor, the June 23rd motion to dismiss simply corrects the caption,
But it's.
but Your Honor, if I may answer the
The
question.
rule doesn't allow it, does it?
This-
Does Rule 9A allow me to send a motion and then a few days later say, yeah, I changed my mind, here's another one?
Nothing was changed. We didn't change. No one changed their mind, Judge. What happened was there was an amended complaint which simply adds additional factual allegations. There's no
But
new.
why wouldn't you ask for permission? Why did you just do it?
Because we thought we could reasonably deal with counsel. That's why, Judge.
Yeah, but it-
And I don't think there's any prejudice to them by getting a complaint.
There's prejudice to the process, and I just don't know, it just seems to me this decision such as that, I don't know whether it's a showing of entitlement or arrogance, I don't know which it is.
It's neither, Judge. It's simply correcting a motion to dismiss a complaint that was subsequently amended, that has absolutely no change substantively, no change in parties, counts, theories, or anything other than additional facts, which we address in reply. So it's a correction of the original motion. We reached out to counsel after they pointed it out to us, asked them,
They told you they weren't gonna accept it,
well,
so you decided, okay, I don't care what they say, we're just gonna do it.
how are they prejudiced? We even offered them more time to respond to it. It's form over substance, Judge, with all due respect. The arguments are still presented. The theory that they're advancing is still addressed. There's no prejudice, there's no change except some number paragraphs, and where it said Plymouth, it had said Barnstable because this is where the case originally originated. So while I understand the mechanics of the process under 9A, we really haven't violated anything. We've responded to the amended complaint, which is purely an extension of the original complaint. There's cases that hold for that position. It's not an inoperative, superseded complaint. It's an extension of what was initially filed. And we've addressed the arguments.
It was filed as of right, so that's the operative complaint, the amended complaint was filed as of right.
But it still extends what was initially pled at the initiation of this lawsuit, which is a theory that has not changed by virtue of an amendment. What happens in the amendment is some additional factual allegations are included.
So why didn't you respond, why didn't you address those in your June 23rd, for example?
We addressed it in the reply, Your Honor.
Right, but you could have done it in the amended motion, couldn't you? Because the reply is not to argue stuff you might have missed. The reply is to talk about new stuff.
But we are under no obligation to address every single factual
You're
allegation.
not, but you're also you don't have the ability just to throw in a reply because you want to put in something you might have forgotten to address.
The purpose of a reply is to reply to the arguments that are in the opposition to the motion to dismiss, which is what we've done. And I'm here to argue it verbally as well.
Let's talk then for a moment about the reference to the statements that Ms. Reed made in 2024 to Mr. Muir.
Yes, sir.
And you address that in a reply. First of all, your reply uses the word allegedly in describing Ms. Reed's words. Do you not concede that she said those things?
Well, the alleged is behind what the purpose.
It says her alleged words. That's what your reply says.
Your Honor, I haven't seen the documentary, so I am responding and advocating for my client's argument. So I'm not going to admit that that's what she said until I've seen it. So for the purposes of argument, I must have used the word allegedly. But the arguments are that is petitioning activity.
Let's take a look at paragraph 33.
Of the complaint?
Yeah. And
Oh man, Sellingson's getting a beat down because he didn't do things correctly. Oh, this is not good. Oh my goodness.
Paragraph 33 of the amended complaint, Your Honor.
yes. And that's where the plaintiff's alleged Ms. Reed was the source of a blog post.
Just Nana, it's bananas. It's just bananas. Why they didn't do this? Why is Sellingsing backtracking? It's so bonkers to me.
Mr. O'Keefe. use that.
Why are they doing
just as an
this?
example. My broader question is, how are Ms. Reed's statements to Mr. Carney, not things in court filings, but her statements accusing the plaintiffs of murder, petitioning activity?
Oh my gosh.
Somebody else or others were. That's in connection with that judicial proceeding.
I
That's
can't even tell
protected
you.
petitioning activity. The complaint rests solely on that type of language. It's also knowing that Mr. Kearney obviously has
Okay,
a
hang on.
wider audience is arguably to enlist participation. So at least 2 statements of the anti-SLAPP statute would cover those statements. From day one, she's taken the position it wasn't done. She was prosecuted twice and acquitted.
Oh my gosh. Sellingson.
Let's go back for a moment, if you could, to Ms. Reed's statements to Mr.
Okay.
Muir.
Yes, sir.
Misread statements to Mr. Carney.
Within the scope of the anti-SLAPP statute. One of the categories being encouraging consideration and review, reasonably likely to enlist participation. So in the criminal trial, the case went to the jury on June 25th, 2024, correct?
Yes.
I don't know why this judge is picking on them.
22nd, 2024, Ms. Reed gave an interview to Mr. Muir, correct?
Correct.
Let's look at paragraph 97, 98 of the amendment.
Judge Gilday is a stickler for rules. And if you start to go around the rules and you don't do things correctly, he's not happy. And you would think that Sellingson and his team already know this based upon
There,
the other case.
Ms. Reed states, among other things, I know Brian Higgins had a role in helping kill him, helped him get him in the snow, and helped frame me. And then Mr. Muir asked Ms. Reed.
They're
"You
talking
make
about
such
Reed's
strong
statements about
but I think
Aiden
Colin
Carney
would-
or Brian
I don't
Higgins.
know how without getting sued, because I don't even know if you're gonna. And Ms. Reed responds, if Colin can prove I'm lying, and this is defamatory, he can sue me. So my question is, how can statements by Ms. Reed outside of a criminal trial, 3 days before the case went to the jury, to your own words, a documentary filmmaker, that apparently were not going to be released to the public at that time,
Hang on.
be
Judge is
considered
talking.
petitioning activity? It's almost the claims and statements to the filmmaker are petitioning activity appears to presume that Ms. Reed was either seeking to influence the jury or she knew there was going to be a hung jury. How could it possibly be petitioning activity?
Well, firstly, the criminal trial is still ongoing. The jury hasn't got the case yet. The jury hasn't decided. So the judicial proceeding is still ongoing. And if we actually look at what happened, there was a mistrial, which
So the
leads to a
intent was for
second.
Mr. Muir to release those statements?
I'm sorry, Your Honor?
The intent was for Mr. Muir to release those statements prior to the jury?
Well, I don't know what the intent was with respect to when this documentary was going to be released.
Sure as hell wasn't going to be released in 3 days, was it?
Well, even if it's going to be released in the future, she ultimately is still in the process of being prosecuted. The trial hasn't ended. It's still under adjudication. It's still a proceeding. These are still statements. These are still protected petitioning speech, regardless of what Mr. Muir's intention was or when he was going to release his documentary. But ultimately, there's a mistrial, and she's tried again and has the same defense, and that leads to an actual acquittal. So this is also to enlist participation. This is also in connection with the judicial proceeding that's ongoing, and therefore falls squarely
Wow.
into the statute's definition.
If it's made 3 days during a pending criminal trial, made 3 days before
It's made
the case is
3 days
going to
before
the jury,
pending trial.
and how is it made to enlist public participation?
In the future, because
But is it it's not
at the time, but it's still part of a judicial.
it's not disseminated to the
If
public
you take
just yet.
aside the public participation enlistment aspect of the statute. It's still in connection with the judicial proceeding. Whether or not the documentary was published that night, that morning, or 3 weeks from now,
Right.
it's still in connection with the judicial proceeding. It's still petitioning activity. The statute doesn't say when the judicial proceeding has to have concluded by. It says in connection with the judicial proceeding. Taken to its logical conclusion, it might be that she's even been, hypothetically speaking, convicted, and she can still say those things and argue it's in the anti-SLAPP statute protection, because it's in connection with the judicial proceeding.
Is the plaintiff want to respond?
Yes, Your Honor, I do.
Okay, hang on.
What
I am going to
Ms.
pause
Reed-
for just a second. Oh my gosh. Okay. We'll get back to it in just a second. I have to pause here for a second. The judge is saying, hey, she's made these statements to a documentary film person. This was in her first trial. And she said, oh, if I make these statements or whatever, I could be sued for this. She's talking about Brian Higgins and Brian Higgins' role in, leaving John on the lawn. And so she made these statements. And the judge is saying, okay, well, these are defamatory statements. But Sellingson is arguing, well, you don't know when the documentary was going to come out. You don't know if it was going to come out today, tomorrow, or whenever. And he's like, well, isn't that going to influence the jury? So to me, that's just like, if you are an accused person and you're saying that somebody else could have done it to somebody else, right? If you're saying it to a third party journalist or whatever, you have to be really careful about what you say, because you could be sued. That's what this seems like to me. So you let me know in the comments. These are great legal arguments, right? You have to be careful what you say, because you can get sued. Now, mind you, there's more to it than just these little tidbits. But wow. Yeah, this is just wow. Okay, we're going to continue. So if I'm on YouTube and stuff and I don't talk, I'm trying to let the lawyers talk, but I talk on TikTok because TikTok doesn't know what's going on. But we'll come back to everything. Just, you can leave your questions and stuff. We'll come back and talk. Here we go.
Counsel has just suggested is that there is no limit. There need be no nexus.
No limit,
between
no
what
nexus.
She says, and the likelihood or the plausibility that it will reach a governmental body. He just said that even post-conviction, and we actually have allegations that she made defamatory statements, both she and Mr. Carney, post-verdict. But what they're saying is even post-verdict, because she in the past had been subject to a criminal prosecution, she is free to defame people, no matter the audience. Just because she's commenting on somebody else's guilt, not her own, somebody else's guilt. Blakesley says exactly the opposite. Blakesley says that this court is required to assess if a plausible nexus exists, and in doing that, analyze the objective indicia of a party's intent to influence a government proceeding, such as the timing, audience, and content of the statement. That's exactly what you were just trying to do here. With respect to the Murr allegations, the audience of Ms. Reed's statement to Ms. Murr is not the broader public. She's saying that in a closed private room to Ms. Murr and the small production staff around her. Now, if that statement is later published, she may be on the hook for additional damages, but the defamation that she articulates to Ms. Murr is not enlisting public participation in anything. It is a private statement to Ms. Murr and her small production staff. And as you point out, I think, or I'll point it out, the idea that there was a plausible nexus between that statement and something that was under review by a judicial body is so far-fetched as to be totally unreasonable. That statement wasn't going to reach any judicial body. By the way, Karen Reed, if she wanted to reach a judicial body, had every opportunity to do that. Instead, she's talking to a documentarian in private and accusing all of my plaintiffs of murder. Period. There is no nexus to any judicial proceeding. And this does get to the post-verdict statements that we allege she made and that Mr. Carney has made up until last month. I can touch on that now because the issue of having to analyze whether there's a plausible nexus is one that's going to apply equally to those statements. And what Ms. Reed has argued is that her statements in, I believe, 2026 to the Rotten Mango podcast, in which she again defames our client post-verdict, well, she says, she argues, that has a plausible nexus to the O'Keefe family's civil case against me, and that by accusing these innocent people of murder, perhaps I can convince the O'Keefe family to drop their case against me. The O'Keefe family isn't a governmental body. They're a private litigant. That's not petitioning activity. And Mr. Carney equally has a lame excuse for his post-verdict statements where he says, well, there's the statute of limitations for murder still exists. I can spout accusations of murder into the void, and there's some plausible, some governmental entity will pick that up and then prosecute these innocent people for murder. That is simply not plausible. It's not reasonable. It's an after-the-fact justification that has no support in any of the case law. Go ahead.
Attorney Sellingson, you want to
Okay, I had to pause there. All right. So at the crux of everything that is happening, it seems that because Karen and Aiden didn't go to the police to say, hey, these people are murderers, then now it's like, okay, well, now you've defamed them. But in Aiden's case, they're saying he did go to the police. He emailed Michael Morrissey. He protested in front of the State House. He obviously protested in front of Dedham. Karen Reed obviously couldn't do those things. Now, did Karen Reed go tell the police that somebody else did it? This is just bananas to me. Like you're just going around in circles and circles and circles. So they're saying if they did this, but then if they did that, then they didn't do this, and then they did that. So 1 minute they're saying, well, you didn't do this, but then they did do this. So my thoughts initially thus far is that when I saw this defamation case, I really thought that the Ham defendants had one against Aiden Carney. And you can come for me in the comments all you want to, but I do think that Aiden Carney defamed them. And I think that this will go forward, I think, on Aiden Carney. Now, Karen Reed, there are very small strings that could lead her to go to the defamation. Now, I didn't really know about these statements about to the newspaper people. Well, I guess it's not newspaper. She's to the documentarians and what she said to them and kind of how that's going to lead them down the path. But we'll see. All right, we're going to continue. So, I mean, let's play hypothetical here. It doesn't matter at this point moving forward whether or not if they get a new DA elected, if Adam Deitch gets elected and Adam Deitch says that he's going to go ahead and he's going to put charges on these other people, the Ham defendants, for John O'Keefe's incident, right? Even if they do that, this lawsuit has already filed. It's on the tracks. It's moving forward. And the statements and everything that they made prior to this, it still is going to happen. So even if charges do get on them, this defamation case is still going to go forward. Does it make sense? The words are already out. The horse is out of the barn. It's going to go. So All right, let's continue because this is really good. This is a really good legal discussion. Both sides have great points. It's amazing. So if you're just joining me on TikTok, I'm also live on YouTube or Facebook. Legally is 123 if you want to see this court case. And I hate to pause, but sometimes we have to pause and talk about what's going on so that people can understand and know. Do the likey things and the subscribey things while I'm talking. Here we go.
Your Honor, the statements are still in connection with the judicial proceeding.
Okay. Attorney Pyle, I guess the characterization really excuse my warrant some response.
Thank you, Your Honor. And I'll note that the argument that was just made, that post-verdict statements can't be petitioning, was not connected to any element of the definition of petitioning in the anti-SLAPP statute. So I'll read one. Any statement reasonably likely would encourage consideration or review of an issue by an executive body. The Norfolk DA's office still exists. Karen Reed has been found not guilty. If Karen Reed's not guilty, somebody else is guilty. Aidan Carney fervently believes that the plaintiffs are guilty. It is still possible for them to be charged. In fact, one of the allegedly defamatory statements that they identify in this case is a TV interview that he did, not one of his YouTube videos, but a stand-up TV interview right after the verdict. And Aidan Carney said, "I would hope now that Karen Reed has been found not guilty, we can all unite and demand that the Alberts and the McCabe's be charged with the killing of John O'Keefe because they're the ones who did it." That is a demand on the government to bring charges. It is a statement also that is reasonably likely to bring about further public participation to demand that charges now be brought against the real killers. That is petitioning.
Attorney Stutz, didn't give you the chance to argue your motions. What would you like to add?
Your Honor, what I'd like to add is, without regurgitating what we've already said about stage one of the Bristol Asphalt Framework, the sole crux of the complaint, the amended complaint, this lawsuit against my client, is solely based on statements that are petitioning activity protected and immunizing her under the anti-SLAPP statute. The second prong of the framework requires the burden to shift back to the plaintiffs to show that the statements are devoid of any factual support or any legal basis. We have put forward enough evidence. You referenced the affidavit and the transcripts attached to my declaration affidavit. That's in there, and they cited to in our brief. But the facts that established stage two of the framework, most importantly, my client was acquitted of the prosecution's charge that she was responsible for John O'Keefe. The case of Faber versus Walton, the holding was judgment in favor of a party to litigation is conclusive evidence that petitioning activity was not devoid of any reasonable factual or arguable basis in law. She submitted an affidavit that she did not strike Mr. O'Keefe with her vehicle.
What's the nexus between the finding of the Norfolk Superior Court in a criminal case against one defendant to claims against these plaintiffs?
Because her petitioning speech has to be supported by facts. They have to disprove that there are facts to support her petitioning speech. So that fact is highly relevant. She didn't strike Mr. O'Keefe with her vehicle. The chief medical examiner, Dr. Irini Scordi-Bello, testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike, but they were consistent with a physical altercation. Mr. O'Keefe did not show signs of a physical altercation before Miss Reed dropped him off at 34 Fairview Road in Canton. They did not have an altercation.
Okay, I'm sorry. I have to pause. You guys let me know in the comments. Scorty Bello didn't say that. Scorty Bello didn't say that. She didn't say Scorty Bello is the medical examiner in Karen Reed's case. She didn't say that he had a physical altercation. She just said that, he had with the counter coup on the back of his head. She didn't say it was a physical altercation. I wonder if the defense or the plaintiff are going to come back and say that. Oh, you let me know in the comments. You're stating facts, not in evidence, Mr. Sellingson. All right, we'll continue.
At the Albert's house, he suffered a wound on the back of his head, which was consistent with falling on a ridge surface.
Right, he fell and had a ridge surface thing on the back of his head. Not that he was in a fight.
In the basement garage at 34 Fairview Road. Mr. O'Keefe had wounds on his arm, consistent with a dog bite. There was a German Shepherd in the home with a history of aggression.
Oh boy,
That's
you're.
also testimony from the trial.
I
Mr.
appreciate what
O'Keefe's
you're
phone
saying,
was at some
Sellingson,
point
but
inside the Albert's home. That's testimony from Mr. Ian Whiffen.
okay, if you guys, so I'm sorry, words matter. Words matter. Did you see Alan Jackson yesterday when he was going over his speech and he was talking about how words really matter and how he was talking about Cosgrove saying, we, who's the we? By the way, the we might be Mark Diller. We'll talk about that. Is Cosgrove in bed with Mark Diller to get Karen Reed's phones? Probably. I wonder if he's going to be called out on this. Hang on.
Ms. McCabe used her phone at 2:27 a.m. on January 29th to type in how long it takes for a person to die in the cold. That's the testimony of Richard Green from the trial. In the early morning hours, January 29th, 2022, Mr. O'Keefe's body was not present where it was later found. That's the testimony of the plow driver, Lucky Lawford. And then there's a testimony from Dr. La Posada, the former chief medical examiner for Rhode Island and a professor at Brown University, who opined that Mr. O'Keefe died from a massive skull fracture that was inconsistent with a vehicle strike. Those are the facts that the plaintiffs now have to prove are somehow devoid. We're devoid of proof. So the statements are petitioning. They are covered by the anti-SLAPP statute. The amended complaint rests solely on those statements. And the support for her petitioning activity is factually supported by what I've just read and what I've submitted to the court attached to my affidavit. For those reasons, Your Honor, for those reasons, I ask that the court dismiss the lawsuit against my client and award her attorney's fees as is provided under the anti-SLAPP statute.
Thank you, Attorney Sellingson. Attorney Mann, you want to respond to Ms. Reed's arguments?
Just briefly, Your Honor. And before I do, I did just want to point out in response to the court's question earlier to Attorney Pyle about whether posting to social media is by its very nature petitioning activity. We cite the Sheehan case in our brief, which stands for exactly the opposite. I hesitate, Your Honor, to even engage with what I just heard because I think it's prejudicial to my clients to even entertain what I believe is just nonsensical recitation of evidence that doesn't implicate any of them in crimes that has been shown to be discredited. And I'll start by pointing out that he doesn't mention Colin Albert once. Doesn't mention him once. And the reason he doesn't mention him once is because he knows that the undisputed evidence, as we present in our brief, is that Colin Albert wasn't even there when Mr. O'Keefe arrived. And because he knows that the other evidence that they suggested implicated Colin Albert in some sort of altercation, that is that at some point he had scab knuckles, that they were in possession of photographs that show him before that and after Mr. O'Keefe's death with completely uninjured knuckles. So I only raise that to show just how frivolous these arguments are with respect to Ms. McCabe. Attorney Seligson just said again here in open court that Ms. McCabe Googled how long to dine cold at 2:27 a.m. That is not true. That was established to be definitively not true in the second trial. Ms. Reed did not allege it in the second trial. She didn't even call the discredited expert who Mr. Seligson just cited. To the contrary, Celebrite officials who managed that software testified without contest that that server showed up at 2:27 a.m. because a previously opened window was used to conduct the search after 6 in the morning. And that was a feature of the software and no evidence at all that the search had happened at that time. And obviously, it's absurd to even suggest it because then there are two searches, I believe it's 6:23 and 6:20.
Okay, he just said that he wasn't going to. He said he wasn't going to go over what Seligson just said, but here he is. Now he's like, my client didn't make that search at 2:27, and Celebrite even said that she didn't do it. I realize you have to advocate for your clients, and I realize how controversial and how explosive all of this is. It's so explosive, and it's a lot. It's a he said, she said, they said, whatever. More or less, if you wrap it up in a package, did Karen Reed and Aidan Carney make statements that are defamatory towards these defendants or plaintiffs? Sorry, they're the plaintiffs. Well, they were defendants. They're called house defendants in the case. Did they make statements against these plaintiffs that were defamatory? And is this motion going to be dismissed? But now we're going into the minutia of everything. Instead of talking about case law, it's that your client said this and your client said that. Let's go. Let's wrap this up. It's going to be wrapped up soon. Let's continue.
That are miskeyed in exactly the same way as the prior search. It's just nonsense. And I think that the important thing is, as you point out, the fact that a jury was not able to reach a verdict as to this, the fact that a jury concluded that there was not sufficient evidence beyond a reasonable doubt to convict Ms. Reed of these crimes is not affirmative evidence that anybody else committed them, much less witnesses who have never been targets, never been subjects, testified in open court multiple times. It's just a...
Okay, so he just said witnesses that haven't been targets, witnesses that haven't been well, I'm sorry, sir. They didn't do a thorough investigation. You guys let me know in the comments. Do you think that Michael Proctor, MSP, and what have you, did they do a thorough investigation? Now, I'm not saying they did it. I'm not saying Karen Reed did it. It's not a fact of who did what. The investigation was flawed. Right? Can we all agree the investigation was not as thorough as it should have been?
Let's continue. Offensive to hear that type of argument here.
Oh, it's
now, I don't think you're ever
offensive
going
that
to get to that stage of
that
the analysis.
He hears
because I
that
think as we've
argument.
shown, none of the allegations you've made against Ms. or Mr. Carney, petitioning activity, have you shown it? I'm sorry?
None of them?
None of them. I mean, I think there is, as Mr. Pyle has suggested, Mr. Carney separately, now I'm not acknowledging that this was petitioning or not, but Mr. Carney has engaged in criticism of the Norfolk DA's office,
the criticism of Norfolk District.
None of that is at issue.
Police. None of that's at issue in this case.
None of his accusations of our clients that they committed murder was petitioning activity. Not a single one. Not a single one. And there is no case to suggest that that sort of accusation against a private citizen, untethered to any effort to report to the government, is petitioning. None. And so the question I think that this case presents is whether or not this court is going to radically expand anti-SLAPP protections to include what historically has been considered defamation per se, and shut the courthouse doors to people like my clients who've come here seeking and invoking the court's protection to press their claims, or whether they will have no civil recourse, not just them, but any resident of Massachusetts who is falsely accused of a crime by another citizen untethered to any petitioning activity, whether they will have civil remedies or not. And to me, the case law that we cite in our brief makes it clear that the narrow purpose for which the anti-SLAPP statute was enacted certainly does not extend to what historically has always been understood to be defamation per se, the worst type of defamation, the accusation of one citizen of another, a false accusation that they've committed a heinous crime of murder when that has not been tethered to any report, any petition, anything with respect to government. Thank you.
Attorney Allison, anything else?
Okay, he's saying that the Ham plaintiffs have never been tethered to any reports or anything that they have committed a crime. Okay. Again, I go back to the police didn't investigate. How do you know whether they did or they didn't commit a crime? They didn't investigate you for a crime. So we'll never know at this moment today, as we're speaking on the 14th of July, no investigation into them, into committing any atrocities against John O'Keefe, have never been thoroughly vetted. Can we all agree on that? Will they ever be? We don't know. Even if Adam Deitch does get into Norfolk District Attorney's thing, is he even going to open up this can of worms? You let me know in the comments. We're getting ready. Aidan Carney's lawyer is going to get up to say one more thing. It said I had a message on here, but I don't know if I do or I don't. So sometimes I can read your messages on TikTok and sometimes I can't. So I doing the best that I can. All right. Aidan Carney's attorney is back up again. So just remember, just sort of in a plain sort of way that this is going, the Karen Reed and Aidan Carney's attorneys did what's called an anti-SLAPP, which means, okay, we want this case to stop right here dead in its tracks. And these are the reasons why. And we don't think that they've made a claim enough for this to continue to proceed. I'm putting it in the shortest, easiest terms as possible, right? And so they're arguing that these were petitioning exercises that Karen and Aidan were doing. And in the plaintiff's argument is saying, well, part of the law states that you have to, if you're saying somebody's committed a crime, you have to go report it to the government. Well, did Aidan Carney report it to the government? Could Karen Reed, even at the time, because she was being accused of things, she was being charged with this, could she go to them and legally do that? That's sort of the arguments that they're making. Let's continue.
No, Your Honor, stand by my
Yes, Your Honor. The suggestion is repeatedly made that accusations of murder against private people are not protected by the anti-SLAPP law. That is not the law. And Mr. Maddy just said that those statements can't be protected by the quote, very narrow purposes for which the anti-SLAPP statute was enacted. The Supreme Judicial Court in the Duracraft case noted that the language of the anti-SLAPP statute is in fact very broad. It broadly protects petitioning activity. Yes, even when it results in the dismissal of an otherwise meritorious defamation claim. It has long been the law, at least since McDonald versus Pate, which we've cited in our brief, that anti-SLAPP applies to defamation claims. It doesn't matter if it's defamation per se, which is one of the old common law characterizations of defamation, the commission of a crime, loathsome disease, or whether it's defamation per quad. It applies to defamation cases. These plaintiffs' defamation claim is based solely on Mr. Carney's accusations that they committed murder, and those accusations were inextricably bound up in his protests against the prosecution of Karen Reed and the failure of the government to investigate the plaintiffs. The notion that there's no reasonable factual support for Mr. Carney's petitioning activity is laughable, given the extensive evidence that you've heard about at the trial and that our brief explains in great detail. Mr. Matty didn't say anything about the Ford Edge that Lucky Loughran saw parked in front of 34 Fairview. There's no explanation for that. The notion that he cannot make these statements, comment on a pending criminal case in order to get people involved in this matter is simply not accurate. The anti-SLAPP statute provides very broad protection for petitioning activity. And it doesn't require that anybody report anything to the government. It extends to statements that are made that are intended indirectly or directly to reach the government. That concludes my argument on the anti-SLAPP motion. I did want to raise one other housekeeping matter with Your Honor.
All right, sorry, hang on just a second before he goes to housekeeping. All right, so he's saying, listen, the anti-SLAPP thing is very broad, and that Aidan Carney is right on the path for that. And you're saying that he didn't say anything to the government. Well, sure he did. And that they didn't, the notion that he didn't bring up, the plaintiffs didn't bring up the Ford Edge and Lucky Loughran. I'm not really sure where he's going with that, but he's making some really good arguments for Aidan Carney. But I have to say this. You know, there's always like a line in the sand, right? There's a line in the sand, and you sometimes, if you say something, you get up to that line, and then if you just tiptoe over that line, could that be too much? Is Aidan Carney's statements too much? Now, I am a proponent of the First Amendment. As you see here, I get to say things that I want to say. But you do have to be careful to a point that you're not defaming other people. Did Aidan Carney defame these defendants? We'll wait to see what Judge Gilday's order is going to be. So now we're continuing. Aidan Carney's lawyer wants to say something else on another matter.
In order so that the record can be clear. Back at the Rule 16 conference, Your Honor asked the plaintiffs to file a thumb drive containing all of the allegedly defamatory videos. We got it. You have received such a thumb drive? Oh, I didn't know that because I didn't receive a copy. I'm glad that thumb drive is now in the record. I know there was a thumb drive attached to the anti-SLAPP motion that may have contained a few of the videos. I'm not sure if they.
Right?
I don't think we noted that we received it, no.
Okay, all right. They sent it in. They sent a thumb drive in with the links and all that.
Containing every allegedly defamatory video in the case? Okay. Thank you, Your Honor. That satisfies me on the issue. I would request a copy.
Happy to give you a copy. Your Honor, very briefly in response. The Duracraft case cited by counsel.
It was cited by everyone.
Which
I cited it too, so.
Which I relied on in saying that the purposes of the anti-SLAPP statute are narrow, reads as follows. Section 59H is, quote, strong medicine and used only in a limited context, requiring, quote, necessarily narrow and strict construction. That's what I was relying on when I made that observation to the court. And the last thing I'll say is, it is of course true that the anti-SLAPP statute applies to defamation. The point that we made, and I think the point that counsel doesn't even dispute, is that where the defamation involves accusation of a private citizen of murder, and that accusation is not made to a law enforcement agency or the government, that it has never been given petitioning protection.
Okay. Thank you all for your arguments. The matter will be taken under advisement. Can I speak with all counsel at the side of the bench, please?
They keep going back to, well, you didn't tell the government. You didn't tell the government. You didn't tell the government. They're getting stuck. Oh boy, that was very loud.
Side. We have, I repeat, sidebar. Hello.
Okay, I don't know why he's.
Thank you all for helping Towel Stream break a brand new 4,000 viewers simultaneously. That's more than even watched.
Okay. So they're sidebarring. Let's see what else is going
Some
on.
reports, and I'll run outside the courtroom and I'll tell you what happened. So this was Aiden Turtleboy Carney and Karen Reed's motion.
Okay, that is Grant Smith Ellis. He was the one that brought us this thing. Oh, well, apparently we could have gotten it from Channel 5, but I didn't see where the stream was. Anyways, who cares? Here we are. Hello. All right, everybody. That's it. Oh, all right. It's question time, question time, question time. Thank you, everybody, for joining me. Make sure to do the like and the subscribe. All right, so let's discuss. Let's discuss. Oh, wow. Okay, so Aiden Carney is arguing that he and Karen Reed argue that their public statements accusing witnesses Brian Albert, Colin Albert, Brian Higgins, and Jennifer McCabe involved in John O'Keefe's deaths are legally tied to an active, ongoing judicial proceeding. And under the statute, the statements made in connection with an issue under consideration by a judicial body qualify as a protected petitioning activity. Because Carney's reporting and advocacy and commentary directly mirrored the third-party culprit defense presented by Karen Reed and her legal team, asserts a strong structural link to the case. However, Massachusetts courts historically look closer at whether Aiden's broad internet commentary is a genuine effort to influence government or judicial action, or simply generalized public speech. So as you heard in this anti-SLAPP, they weren't talking about First Amendment, right? They're not talking about First Amendment protected speech. They're talking about whether or not this is what's called a protected petitioning activity. And we'll get into that specific in just a second. So if Judge Gilday rules that Carney's statements qualify as a petitioning activity, it shifts the burden entirely into the plaintiffs to defeat the motion. For the plaintiffs, which remember are the Ham plaintiffs, Higgins, Alberts, McCabe's, the plaintiffs must show that Carney's statements were completely what we call, again, devoid of reasonable factual support and any arguable basis in law. The anti-SLAPP standard is a low threshold for defense. Aiden only needs to establish a degree of evidence, reasonable suspicion, plausible inference to justify his commentary. Given the highly publicized and complex and contested nature of this evidence and the underlying criminal case, proving Carney had zero factual basis is a steep hurdle for the plaintiffs. The plaintiffs must conclusively show that Carney protected activities directly caused them distinct, demonstrable financial and personal harm. So let me know if you have any comments on that, and then we are going to move on. So just remember, comments are open on the Tickety Talk as well as the Facebook, YouTube. So if you have something you want to ask or what have you, we're going to delve a little bit into this to the best of my ability, okay? All right. That was amazing. Okay, so what about Karen's position? Again, I feel that the claim against Karen is So it bolsters her third-party culprit defense, right? In the defense, she's saying someone else did it. Does she necessarily have to say, yes, someone else did it, etc., and therefore XYZ? Okay, let's see. Can you just imagine Judge Gilday going through all of Aidan Carney's YouTube presentations and links? Okay, so it is possible. Now we know Judge Gilday is not liking Karen Read's attorneys. We can see that clear as day. Why? It seems as though Karen Read's attorneys are just not playing ball with him. They aren't doing things that they should have done, right? Could the Michael Proctor gate be part of that? Maybe. Judge Gilday he does not like courtroom theatrics. He does not like the drama. And you have to make sure that you filed your motions correctly and you did things in the timely manner, etc. Granted, people are saying that the Proctor gate, that he was believing somebody else from somewhere else. It could have been a court clerk or somebody from Proctor's team gave him the information and he went on that and didn't go off of somebody else's. And then it's the he said, she said, and everybody's infighting about what's going on. And Judge Gilday is like, I'm not here for that. And that is when he brought in all of the lawyers and gave him a big spanking. So perhaps Judge Gilday might grant Karen Read's anti-SLAPP motion while denying Aidan Carney's motion. That's what I think might happen. Because Karen Read was a criminal defendant at the time these statements were made. Does that bolster things? I'm not sure. Judge Gilday did say, well, she made these remarks to a journalist. Was she potentially influencing a jury at the time, even though she was still being, she was still on trial? That was a very good question. Okay, so why not Karen Read and why Aidan? Well, just as I said, Karen was on trial. She was in a criminal case, and perhaps she has a constitutional right. So that might be where that's at. And as you heard, Sellingson also said it was devoid of factual basis. Misty, what's devoid of factual basis? It's a statement, it's a legal claim that says absolutely zero evidence, logical or plausible inference, right? It's not about absolute truth. The court doesn't look at whether the statement is 100% true or proven. It looks at whether a reasonable person in that position could have believed it based upon the information they had at the time. So there's what's called the benefit of doubt. The law heavily favors the person filing the anti-SLAPP motion. If the factual basis is simply weak, highly debated, or unproven, it still legally counts as having some basis. Now, it helps Karen because her criminal trial ended in a mistrial with a split jury, and because her defense team introduced expert testimony that the car data and the injuries, et cetera, claims something about alternative suspects, it could be an arguable basis. So here's why it's super tricky for Aidan. And how is Aidan going to get out of this? Well, remember, Mr. Maddie argued very slightly, ever so slightly, that remember that Aidan Carney is profiting off of this, right? He makes money off of his Turtle Boy content on YouTube as well as his blog or his webpage. So while Carney claims his blogging is protected petitioning activity tied to the court case. The plaintiffs, Mr. Maddie, argue that his actions went far beyond legal advocacy. The hundreds of blog posts, the live streams, the public interactions may be viewed by Judge Gilday as generalized public commentary or commercial speech rather than a serious, direct intent to influence a judicial body, right? That's why they keep arguing, hey, he didn't go to the police and he didn't say, oh, these people need to be investigated, even though he kind of did, right? So it's kind of like you're saying one thing out of one side of your mouth, but it's you're arguing something else. All right. So Judge Gilday has already made some sprinklings in how he is frustrated with the case and how Aiden has used social media, right? And that will also bolster in his witness intimidation case as well. Now, until we have some judges who are more apt to understand social media, right? And understand that is where our youngins get their news, right? They're not turning into ABC, NBC, CBS. They're getting their news off of TikTok and Instagram, and not really Facebook, but TikTok and whatever new apps are coming out. That's where they get their news, right? So, is Aiden Carney playing up to the people who use social media to get their news? See, that's where I have a problem, right? I have a problem there. All right. So if the judge determines that Carney's rhetoric was intended to harass witnesses rather to assist a formal legal petition, his anti-SLAPP protection will fail. And then the defamation case will continue on. So let me know in the comments, do you think that Karen Reed her case is going to be dismissed and Aiden's is going to continue on? Or do you think the judge is like, nope, we're headed straight. Both of these are going to continue. So in the defamation case that's happening right now, these two anti-SLAPPs have been filed. They just argued them in front of the judge, and then we'll wait the judge's decision. What's going on again later on today? Well, at 3:00 Eastern time, all of these attorneys, let me think about that. Not Aiden's attorneys, just Karen's attorneys, all have to go over to Boston to go to the federal case. And the federal case is Karen Reed suing the House defendants. And when we say the House defendants, we're talking about Jennifer McCabe, Matt McCabe, Brian Albert, Nicole Albert, Brian Tully, Brian Higgins, Yuri, Michael Proctor, and the town of Canton, I believe. They're all going to eat lunch quickly and then zoom on over to Boston to go do that. Now, unfortunately, we don't get to be there as John Q. Public because it's a federal case. Cameras are not allowed in a federal courtroom, so we'll just have to wait for those who are going to report out to tell us what's going on. And last night, I spoke to Boozy Beauty. I don't know if you know who she is. Some of you probably do. She is going to, I persuaded her, begged her to go and report out. So we'll wait for her report on what's going on there. Now, I do want to talk to you about what happened yesterday in the case where Karen Reed was trying to get her cell phones. So you guys, let me know in the comments if you had seen that. if you were with me and you saw that or you heard about it, did you see the TikToks about it, et cetera, et cetera, et cetera. And make sure to do the likies and the subscribey things, do the hearts on the tickety talk, and do the likies, subscribies, the sherry things on the Facebook. If you haven't subscribed to the channel for YouTube, subscribe, do the likey things, whatever. All right. So yesterday, you heard Alan Jackson fight advocately for getting Karen Read's phones back. So we're going to hearken it back to just a second. When Karen Read was still being accused of killing John O'Keefe, Yuri Buchanan and Brian Tully, I believe. I know it was Brian Tully. I don't know if Yuri was there. Anyways, they had a search warrant to go to Karen Read's house and pick up her other phones. So they already had her initial phone from when she was first arrested. Now they went back to go get her other phones because they believed that Karen and Aiden were having some sort of witness collusion and that they were trying to pin more charges on her and Aiden. So they had a search warrant. So they go over to her house and they say, we're looking for phones. I did a small TikTok on that. They got her phones. And that's as far as it went. They never got a search warrant to search the phones. So the phones are just sitting, I assume, in the Norfolk District Attorney's office, just sitting there waiting. Now, I also think that Karen Read deleted all the information off her phone, so there probably isn't anything. Karen wants her phones back. Karen has no criminal charges on her whatsoever, right? She's not being accused of anything. She has no criminal charges on her. She was acquitted of killing John O'Keefe. That means she didn't do it. Well, it doesn't necessarily mean she didn't do it. There wasn't sufficient evidence to say that she did it based upon Mr. Maddie, what he just said. All right. She wants her phones back. She wants her property back. If you kind of look at the players in this game, all these people are players in a game. It's a big chess game. Robert Cosgrove, who is Aiden Carney's special prosecutor, wants her phones. He wants to see if he can make a connection in Aiden Carney's witness case against Karen Read and or Aiden Carney. What's the connection? He wants the phones. He wants to look at the phones. Judge Krupp said, no, you cannot look at her phones. He made an order saying you cannot order a taint team to go look at the phones. What's a taint team? Taint team is somebody outside of the Norfolk District Attorney's office to go through the phones, download the information, and see if there's any attorney-client privilege, and then he gets the rest. Judge Krupp said no. So Karen Read and her team back in February said, okay, Judge Krupp said no, so now we want the phones back. And then Cosgrove said, oh, well, I'm going to appeal that decision and I need to see where we're going to go and what we are going to do. And I'm not sure how we are going to proceed, etc. If you're a special prosecutor, you are separate from the office that hired you. You're an outside person. You are not to be colluding or inquiring with the Norfolk District Attorney's office as to what they are doing. Who's the puppet master in this? Is Michael Morrissey, who is the head of the Norfolk District Attorney's office, giving you information? Because if that is, that's against the rules. And that's the argument that Alan Jackson made yesterday. Saying you need to be a separate entity. You're not supposed to be colluding with other people to prosecute a case or to get evidence in a case. So who's the we you're talking about? And so, just FYI, they filed motions about this. And you know me, I'm a motions girly. I like to read and see what they said, and I want to hear the arguments. Well, guess what? We can't get the filings on this. No one can. It is bizarre because it's under this search warrant. It is the most bizarrest, weird, backwards anomaly as to how this is filed. So John Q. Public, we the John Q. Public, can't see it. Even lawyers who are not, so normally a lawyer who is not party to the case can go in there and they can usually get things. They can't as well. I asked Queen Corey last night, if you know who Corey Hopkins is. I asked Queen Corey last night. She is, if you don't know who Corey Hopkins is, we call her Queen. She is a lawyer. I want to say, somewhere in the Carolinas, I think. Don't come for me. I think she's in the Carolinas. I can Google it. But anyways, she's a lawyer outside of Massachusetts that has been sending messages to the Norfolk District Attorney's Office, FOIA requests. What's a FOIA request? Freedom of Information Act. So she is the one that has been requesting documents from the government that are public information that the public wants in reference to Karen Read. All of the sidebars, all of the evidence, all of reports. You as the taxpayer are the one that pays for these things. You're paying for Karen Read to be convicted. You're paying for Brian Tully and Michael Proctor to go do these reports. You are the taxpayer that pays for these things. So you get to receive the documents. So she has been the lawyer that has been sending requests to them to get the information. So that's why that's why every once in a while you'll see there's a huge document dump. And that is because information is coming out. By the way, there's still tons left that we don't have. Tons left that we don't have. But Queen Corey, she's the one that's doing all this FOIA stuff. I spoke to her in Boozy's chat yesterday, and I asked her, why can we not see the motions on this? And she's like, it's under a search warrant. It's not even under a regular docketed item. And she's like, nobody can see this. The only people that are involved in seeing this are the parties that are involved, which are Karen Read's attorneys and Cosgrove. All right. So how do we know? We don't even know when that they're going to court to argue this. It was like a birdie told a birdie to who told somebody else, and that's how the public knew. Even though that's why I say it's not on the docket. It's not on the docket because there's no case number for it to go under. Isn't that weird? It's only a search warrant docketed number, which isn't I can't describe it to you. It's not a normal process. All right, so move that aside. So Alan Jackson was like, who's the we? Who's the we, Cosgrove? Who's the we? Who are we talking to? Now, I thought it might be Ken Mello. And if you know, you know. So Ken Mello was the initial person on Aidan Carney's case. He had some health issues, and so they yeeted him off as being special prosecutor. They brought in Robert Cosgrove. And then that's another reason why Aidan Carney's case is still in the weeds. By the way, just want to remind you, on July 20th, next Monday, Aidan Carney's case, motion to dismiss, the mega motion to dismiss, is coming to play. Will it be televised? I don't know just yet. I think it will be. We'll see. All right, so stay tuned. So who is Cosgrove talking to? Who's Cosgrove talking to? Cosgrove, it appears, is talking to Mark Diller. Who is Mark Diller? Mark Diller is the lawyer for the O'Keefe family and the wrongful death suit in Karen Read's case against Karen Read. Mark Diller wants those phones. And if you're like, how do you know that? Well, if you recall back in February where Ben Urbelis and Karen Read were in front of Judge Doolin asking for the phones back, and then that is when Cosgrove was like, well, we need to do this and we need to do that and we need to do this. And then there was a phone call. If it was on my TikTok, there was a phone call that was Mark Diller. saying, Your Honor, I'd like to be heard on this matter. And Judge Julian is like, you're not even a party to this case. And he asked the lawyers if he could even hear Mark Diller, because they could say no, because Mark Diller's not even on this case. He's not a lawyer, he's not a party to this case. And he's like, I'd like to be heard on this. We need to preserve these phones. And the judge is like, Judge Julian, he's like, you're not even a party to this case, but I'll hear you anyways. And so he's like, okay, whatever you say, Diller. Did you guys see who was lurking over on the side in the courtroom yesterday? None other than Mr. Mark Diller. And if you haven't seen it, I might make a TikTok on it showing you where he was sitting. So the courtroom, as we all know, it's the Karen Read courtroom. As you know, it's the main courtroom in the Norfolk District, in the Norfolk County, in Dedham Court, whatever. So there are seats behind, which are the seats for the people who are public, John Q. Public. Even Karen Read and her family were sitting in the public seats. And then there's the bar, right? And those who have passed the bar, the lawyers, were up there. So you've got one seat for Karen Read's team, which was Alan Jackson, Benner Bellis, and our good buddy Evan Wolk was there. If you know who Evan Wolk was, I'll go back over that in just a second. Evan Wolk was the AV person in Karen Read's second trial. He was a Harvard law graduate who was helping out Karen Read's team. And after Karen Read was acquitted, he said that he wanted to go work for Alan Jackson, and he moved to California and is working for Alan Jackson. So it was good to see Evan come back. I would have liked to have seen Eliza Little, but we understand she might be in California working on something else. So those were the three attorneys for Karen Read. And then sitting up front was Robert Cosgrove. But over to the side was Mark Diller. And so to further this discussion of whether or not Cosgrove is colluding with Mark Diller, which he shouldn't be, because Mark Diller is on a completely separate case against Karen Read. Not Aidan Carney, just Karen Read, because it's the wrongful death suit. At the end, when everybody was leaving the courthouse, it has been rumored that Robert Cosgrove doesn't like to come out of the courthouse because he doesn't like to see the media. So he waits for an hour. And so one of the reporters, Grant Smith Ellis, was waiting for Cosgrove. Cosgrove didn't know that until he stepped out of the courthouse. And guess who he stepped out of the courthouse with? That's right, Mr. Mark Diller. And I think Mark Diller was surprised to see somebody filming them. And I don't know if Grant asked Mark Diller any questions. Hang on. But Mark Diller just smiled. He's like, here I am. Here I am. And parties have witnessed Cosgrove and Diller talking that whole entire hour after the hearing had ended. Now, are they talking about coffee, shoes? And if you know when I'm talking about shoes. What are they talking about? What could they possibly be talking about? Are they colluding together? And also, I have to continue to reiterate this. What do they think is on Karen's phones? They have Aidan Carney's complete extraction off of his phone. What do you think you're going to find on Karen's phones? And do you think Karen's dumb enough to have something on her phone? By the way, it's two phones. It's not just one, it's two. And I do believe that there was a statement from Karen Reed that said good luck when she gave him the phones, which means, ha 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 ha, you're not going to find anything, right? No, I'm reading between the lines there, and I'm surmising what Karen Reed is saying when she hands over her phones to the people that she despises, right? Brian Telly, right? So, do you think anything's on Karen's phones? So, and even still, okay, so Karen's fighting to get her phones back. Even when she gets her phones back, they're not hers anymore. Karen Reed's team, her lawyers, have an agreement with Mark Diller that when they get the phones, the lawyers are going to get the phones, they're going to do their bit, and that then the phones go over to Diller. And Diller said that he agreed that they were going to pay for them to be extracted and whatever, XYZ. So there's already a stipulated agreement as to what's going to happen to these phones when these phones are released. So maybe Diller is trying to go. Michelle, you got the shoes. When I say shoes, everybody laughs and wants to see what kind of shoes Cosgrove is wearing. Apparently, so Cosgrove is a retired lawyer. Well, how can it be a lawyer? Robert Cosgrove used to be a judge on the bench in Norfolk, and he has since retired from the bench. And again, when you have your acquaintances, you get to be hired as a special prosecutor in the Norfolk District Attorney's Office, right? I can give you a list of names. Hank Brennan, Ken Mello, Cosgrove, right? Your buddies with the Norfolk District Attorney's Office. They need a special prosecutor. They're going to go with their buddies, right? And if just remind you how much money Hank Brennan made on the second trial in Karen Reed's case. If you know, you know. If you know, you know. All right. So perhaps maybe, here's my thoughts. You let me know what your thoughts are. Perhaps maybe Mark Diller is trying to help Cosgrove get those phones. And that if Cosgrove gets the phones, then the government has to pay for the downloads, etc. And then once the government pays for that, then they give it to everybody else. Maybe that's what he's hoping for. But you also have to say then, that doesn't sound plausible because Mark Diller, wouldn't you just then charge your clients for this information? Or perhaps maybe Diller's not making any money off this case until they win. And what if Mark Diller doesn't win? Then he spent a lot of money. Let me know in the comments what you think. Am I right on or am I way out of left field? Oh my goodness. I know it's a lot. So will Karen Reed get her phones back? You let me know what you think. How do you think it went yesterday? Now, mind you, also, there's so much going on. Remember that Aidan Carney's motion to dismiss is next Monday. And as we already know, Judge Belezos, who took over Robert Cosgrove's job, by the way, if you're like, wow, these things are lots of coincidences. Yeah. And what do we say about coincidences? There are no such things as coincidences, right? And now you can see how the conspiracy theories and all of these things just start to meld into one another and they just keep building and building and building. Yeah, because there are no such things as coincidences. All right. Aidan Carney's case is due to go before Judge Belezos on Monday. Now, I have seen some of the evidence in that case. There are very highly suspicious shenanigans going on. How's that? Shenanigans going on. Hi, Michelle. Some shenanigans going on, right? And if you know, you know, right? Are there other people injecting themselves to try to put charges on Aidan Carney? Was Brian Tully honest in his investigation? Was Cosgrove Mello fed information that might have been played with, that might have been piecemealed to them in order to think that Aidan did XYZ? And then is it a First Amendment right, or is it actually criminal charges? Now remember, Judge Belezos already stated on the record that he didn't want to decide anything in Aidan Carney's situation. He wanted it to go to the jury. And that to me does not sit well with me whatsoever. And it shouldn't sit with you, especially if you live in that county. Because that tells me that this judge isn't going to look at the facts of the case. He isn't going to look at the law. And that basically Mark Betterow and Tim Bradle's motions and their arguments that they're going to make on Monday are moot. That they're not going to mean a thing. That perhaps even though they have the case law in their favor, I'm going to let it go to a jury. When would you like to have a jury trial? And that was immediately what he said. And so Aidan's jury trial isn't scheduled until November. Do you think that Judge Julian is going to wait to make a ruling on Kieran Reed's phone until after the motion to dismiss is made and a ruling on that case is made? Now, usually Judge Julian does rule right away. But since one thing is connected to another that connects something else, and Michael Morrissey is still the head of Norfolk District Attorneys, could they possibly just be waiting? Then other people are asking whether or not, even if Adam Deitch does get elected, could he potentially invoke himself in the Kieran Reed, or, well, he can invoke himself in anything. Will he invoke himself into Aidan Carney's witness intimidation case? Well, if I'm not mistaken, and you can let me know, even if Adam Deitch gets elected in November, he doesn't take office until January of 2027. He doesn't immediately get into office right away. He doesn't take office until 2027. So if Aidan Carney case gets on the tracks and goes and moves towards a trial in November, yeah, if Adam Deitch is elected, he can't do anything because he doesn't take office until January. So Adam Deitch isn't coming to save Aidan Carney. It was also brought to my attention that Adam Deitch, I have some news for you. Did you hear this rumor? And I think I'm going to make a TikTok on this. All right. So last night in Boozy Beauty's stream that she had last night, did you know? So let me know in the chat when the feds were investigating in the Kieran Reed case. Remember, we don't know what the feds exactly were investigating. They were investigating something, but they initially were investigating the Kieran Reed case, and they went up to Jennifer McCabe and they wanted to talk to her. And remember, she said, "I'm not Jennifer McCabe, I'm Nicole." Or, "I'm Nicole." She said she was her sister to an FBI agent, right? So we know she wasn't truthful to the FBI agent. Do you know who that person was? Any guesses? Any guesses? Does anybody know who that person was? Are you ready? It was Adam Deitch. That's right. Jennifer McCabe. Now, Adam Deitch was with the U.S. Attorney's Office, so he was an AUSA, not necessarily the feds, but he probably was there with some federal agents, right? So he was a United States AUSA, Assistant United States Attorney. I think that's what it stands for. So he was an attorney in the case. And he lied to Jennifer McCabe. If that's not a turn of events, I don't know what is. Because if Adam Deitch is now going to be the district attorney of your county, ooh, do you think that he could go after her for something? It would be vindictive if he did. But I mean, look, the Norfolk District Attorney's Office currently right now is very vindictive towards a lot of people. And when I say vindictive, I mean, so you have the option of whether or not to prosecute somebody, right? Or not to prosecute somebody, right? And when I say not to prosecute somebody, we're talking about the Sandra Birchmore case and them not doing their due diligence. I also want to talk about not doing your due diligence with Michael Proctor. We talked a little bit about Miles King yesterday. Adam Lawley is going to be barbecued again by Rosemary Scapiccio. Mark your calendars for August the 27th. It is the barbecue of Adam Lawley Part 2. Adam Lawley is an assistant district attorney in the Norfolk County office. He's no longer on that Miles King case, just FYI. If you didn't know, you know. But he was initially with Michael Proctor, and that Rosemary Scapiccio continued to ask him, where are the search warrants for Miles King? She's trying to do discovery on this case. She wants the case is moving forward. She doesn't have the evidence. How is she able to defend this man if she doesn't have the evidence? And so she keeps going to Adam Lawley. Where is this? Where is this? Where is this? And he's like, you know. And so then she kept filing motions in court saying, Your Honor, I've asked for this. And you know, as well as I know, it depends on what judge you get, but they just keep kicking the can down the road. Okay, well, when you get that, come back. Oh, when you do this, get back. And make sure you talk to one another when you get back. There is no compelling any of the lawyers in the Norfolk District Attorney's Office to do jack squat. Everybody just kind of like, whatever. So Rosemary Scapiccio was like, okay, you want to play that game? Well, my client is in jail right now. And since you've missed the discovery deadline, I want him out of jail. So that's what she did. She advocated for Miles King to get out of jail. Now he blew it. We all know that Miles King blew it. Miles King is in federal custody right now because Miles King was modifying magazines for pew-pews. And let's say a magazine normally holds 10 bullets. He modified them to do 30. So it wasn't just a ping, ping, ping. It was a ping, 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 right? And you're not allowed to do that. That's a federal crime. And then he was also selling them. By the way, he was selling them with his buddies. So sadly, some people say that that Miles King might be what's called the bad guy effect, which means that the bad guy gets to go free because of something that the police did or didn't do. So we're talking about Michael Proctor just in general about the things that he didn't do. And so do you think that Michael Proctor was just a bad trooper? He just was lazy and bad at his job. Now, we're basing this off of two cases at the moment. We're basing this off of Karen Reed, and we're basing this off of Miles King. So Adam Lawley is going to be on the stand, and Rosemary Scapiccio, which is very rare, by the way, very rare for an attorney to have a district attorney on the stand and she gets to ask him anything. And if you haven't seen the barbecue of Adam Lawley part 1, let me know. I will link it for you on my Facebook page or wherever you need to see it, so you could see the barbecue of number 1. And it was in front of Judge Krupp. And as some people are like, well, Judge Krupp is corrupt. Take that with a grain of salt. So Rosemary Scapicchio was in the middle of barbecuing Adam Lawley, saying, well, what are your policies and your procedures? I don't know. And you could just see Adam Lawley just like shriveling up. And she's like, well, when you asked him for this search warrant the first time, what did he say? Oh, that he'll get it to me. Okay. And so then when I asked you the second time where it was, you said, what did you say? Oh, he'll get it to me. How come you didn't follow up with him? I just didn't. Okay, the third time that I asked you where they were, how come you didn't go over to him and order him to give it to you? And Rosemary Scapicchio, she's like in mom mode, right? Like when your kids do something wrong. We know that Rosemary Scapicchio has a child because her daughter is in her law practice with her, right? I forget what her name is. So mom mode, right? Rosemary Scapicchio is going mom mode completely on Adam Lawley. Well, when I asked you to do this the first time, how come you didn't do it? Right? She's like, what's going on? So Adam Lawley is going to be, again, skewered and barbecued on the 27th of August, and we are totally here for it, right? Adam Lawley, WTF. And how is it that you're still a district attorney? And how is it that things are continuing? So do you let me know in the comments, if by chance Adam Deitch gets to be elected again, do you think there's going to be some house cleaning? Do you think he's going to be like, you all attorneys go? For example, Greg Conner, who is also running for district attorney in Norfolk County, he too is a practicing attorney under there, right? And we do know that Greg Conner was successful in the Brian Walsh case. And some people were like, well, that was just a layup, right? Brian Walsh practically, told on himself. And so that case was a slam dunk against him, right? It didn't take a genius attorney to get a conviction on that case, right? Again, there's some shenanigans in that case. Brian Tully, Nick Garino, those are two MSP troopers who have a complete controversy on them. So, do you think that Adam Deitch is going to clean house? Bye-bye, Greg Conner. Goodbye, Adam Lawley. We already know Lisa Beatty left. And if you know who Lisa Beatty is, whoo, that woman, if she's a private practice, go hire her. She wasn't given an inch. You want those Proctor texts? No way. Nope. You have to beg, borrow, and steal to get those Proctor texts from her. She wasn't letting anything go until Judge Casper said, let it go. By the way, Judge Casper is the judge that's in Karen Reed's case that they're going to go see later on today. And once we have information on that case, we'll let you know. I mean, it's like all relative, right? All these things are connected, right? Judge Gilday is in 2 cases of the Karen Reed civil saga. Judge Casper is the other one. And the other one hasn't been assigned just yet. FYI. We're watching the docket to see who that one's going to be assigned to. All right. I've been blabbing enough and I just can go on and on and on and on. Are there any questions, comments, concerns, thoughts, ideas? So, what's going on for the rest of the day? I'm going to make some TikToks of some of the stuff I just talked about because some people like just a quick condensed version. We'll see if there's anything else popping off before we get off here. By the way, Corey Hopkins posted some really good stuff on X. If you don't know who Corey Hopkins is, she is, her handle on X is Marbury the Very Mad. It used to be, I think it was Marbury versus Mad, but she's hilarious. She's hilarious. Now, some people love and hate her, etc. but she laid out she's an attorney. She laid out the legal elements in the case of anti-SLAPP versus Karen Reed and Aidan Carney. We've kind of already went over that. And then she also laid out the case for what's going on in the case later on today. So there's another anti-SLAPP motion happening later on today. The House defendants put a SLAPP motion against Karen Reed. And so now she laid that out as well. So that'll be interesting to hear what's going to come out of that as well. So are there any questions? Oh, how do I know all about that stuff and keep it up? Well, if you continue to cover the same things over and over and over again, and I also, just FYI, some of this information doesn't come from me. I have a lot of different sources that I rely on. I listen to some other podcasts. I told you I listened to Boozy Booty last night, and she's been in it since day one. I listen to Melanie Little sometimes. I do listen to Aidan Carney sometimes. I listen to Defense Diaries, The Lawyer You Know, Emily D. Baker sometimes. So I hear a lot of smatterings. I see a lot of stuff on X as well. So that's where I get a lot of things going on. Oh, here's Olivia Lambo. Olivia Lambo is, I believe she's a paralegal. And I believe she is she's paralegal for somebody. So that's where a lot of these things come from. And, you know, I did watch both Karen Reed trials, so I know the players in the game. I know some of the other players outside of the game because I also do other cases. So just remember, this is a small blip on the screen of America. This is just happening in Norfolk County, Massachusetts, right? What is the bill of all? So that's a great question, Miss Chrissy77. What's the bill? Well, guess what? So we play this game, right? We play this game. How many lawyers were there in the courtroom today? And approximately, how much is this costing? Well, today in the defamation case against Aidan Carney and Karen Reed, there were 4 lawyers for the plaintiff's side. I don't know who, or 3. There are 3 lawyers on the plaintiff side. And Mr. Maddie was one. I don't know who the other ones are. I could go and look. I just don't want to. We do know that Damon Sellingson and Mr. Pyle was for Aidan Carney, but there were 2 other lawyers at her desk. There were 4. Then we saw Tim Bradle. And then there was a row of people right behind them. So let's just say, let's guess, because I couldn't see on the camera how many were there. Let's just say there was 10 lawyers. I'm underestimating. We play this game, right? There are 10 lawyers there. Let's say they're charging $1,000 an hour. That hearing was about an hour and a half, right? So they charge $2,000 an hour. $2,000 an hour times 10 is 20 grand. Mind you, they also charge for going there and leaving. And then in Karen Reed's case, those lawyers then now have to be transported from that one to the other one. Same with Mr. Maddie, because he's the lawyer on the other ones as well. So let's just say 20 grand. 20 grand. We're just estimating. Now, some of the lawyers won't, Aidan Carney has 3 lawyers. Let's just say Aidan Carney's lawyers aren't going to go to the other one because he's not a party in that case. So the other party in the case, the other case that's happening is Brian Higgins, Nicole Albert, Brian Albert, Jennifer McCabe, Matt McCabe, Yuri Proctor, Brian Tully, and the town of whatever. let's say all of those people are going to go to this other case. Again, let's just say 10 lawyers, $20,000 times 5. Let's just say today's going to be about $100,000 day. Okay? $100,000. All right, law lovies, I don't see any other questions or anything else going on. So I'm going to end the streams right now. We will come back. I don't think I'm going to be live, but make sure you turn your notifications on because you just never know what's going to pop off. I don't think the federal case is going to be televised at all. Federal cases aren't. They usually don't allow cameras in the courtroom. In fact, they don't even let you bring your cell phones in the courtroom. So we'll report out once we have information from those who were in the courtroom. So we'll get an idea about that. But in the meantime, watch your reels or your TikToks or wherever you get your stuff. I'll be making some content about some of the things that I've witnessed. And we do have other cases that we're covering, people. It's not just all about Karen Read, although I know you love Karen Read's saga. Me too. It's not just about Karen Read. Lindsay Clancy, she's getting ready to go to her trial. We talked about that yesterday a little bit. So we talked about what the prosecution is alleging. We talked about what the defense is alleging. Then we have the Sarah Grace Patrick. Oh, I might come back live for that later on today. We'll see. We'll see what today brings. Sarah Grace Patrick. And then I've got to do some research about the other cases that we're covering. So I usually post like motions and stuff like that, where you can do paper stuff. I either do it on X or Facebook. So make sure you like both of those as well so that you can get notifications of what's kind of going on if I just need to post texts about things. So with that said, make sure to do the likies, the subscribey things, the sharing things, the whole 9 yards to get everything out so that I can continue making this lovely content for you. So thank you so much for joining me. Wheels might see you a little bit later, or I will post if I'm going to go live tomorrow. I probably will, but I'll post it on my Facebook page so that you'll know what's going to be live, etc. So, and as always, send me a comment. Let me know what you're interested in. What cases are you interested in? What do you want to hear more about? Because I do a lot of deep dives into cases and read the motions and all the most. I already told you this a million times. All the T's in the motions. We get all the ins and outs and all of the nooks and crannies of what's going to be presented in a case or what they want to have presented in a case. And if you go over the motions, you know things. Now, in the Lindsay Clancy case, I have not read one motion. In fact, I didn't even want to cover that case, but my dear friend asked me to, so I will. And just FYI, Kevin Wrightington, who is her lawyer, has stipulated with the prosecution that some of the evidence in relation to the children are not going to come in. They've stipulated to that, which is really good because nobody wants to see any of that. Nobody wants to see that. So, but that's Lindsay Clancy's case is a really good case. If you don't know, Lindsay Clancy is being accused of unaliving her 3 children who are ages, I believe, 5, 3, and 7 months, with the exercise bands. It's really gross. And then she tried to harm herself and jump out of a window. And the prosecution is alleging that she premeditated and planned this by sending her husband out to go get some food or something. And that's when she did it. And they're saying that, she wrote a note saying that she didn't like her children, and that is why she did it. And the defense is saying that she suffered from a postpartum psychosis. She was over-medicated, she was overtired, and she didn't have the mental wherewithal to be sane at the time that she did it. So, is it a mental health crisis, or did she intend to do it? Which is really sad. So that's her trial starts next week. All right, law lovies. Thanks for joining me. We'll see you later on. Make sure you have your notifications turned on for what's happening. Thanks for joining me. We'll see you later. Bye-bye. Bye-bye, TikTok. Bye-bye.